Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call. Today is October 25th, 2018. I'll first go over the questions I consider to be frequently asked questions. I will, of course, open the floor for questions that follow those answers. So feel free to press *5 on your phone, *5, if you have a follow-up question in relation to what I'm discussing. No new question, just a follow-up question. My first frequently asked question today is this: can I travel during my naturalization N400 process? And the answer is yes, you can, but the rules are almost the same as they are when you have a green card. Basically, your travel should be kept as short as possible. You can travel, but keep it as short as possible. If during this time, while the naturalization is pending, you stop living in the USA, you would lose your naturalization and could even have trouble keeping your green card. Government keeps track of, they ask you. So let's say you file your application for naturalization today, you get called in for an interview 5 months later. They specifically ask you, have you traveled outside USA between the time you filed your application and now that you're appearing for the interview? And then again, when you go for your oath ceremony, you bring with you a document that talks about whether or not you traveled between the time your interview took place and you came for the oath ceremony. So yes, you can travel during naturalization, but your travel should be kept to the minimal amount and you will be asked about it. *5 if you have a follow-up question. *5. Press *5 on your phone. Okay. This is from New York. Go ahead, New York, I can hear you.
Hi, Rajiv. Thank you very much for your explanation. I want to know, just I'm going for 3 weeks, so is it okay? Is that considered to be short or long?
No issue at all.
Thank you. Thank you, Rajiv.
Good luck, sir. Bye-bye. Okay, let's go on to the next frequently asked question. Let's see. We have one about, yeah, this is also very commonly asked. I've answered this question many times, but well, my answer remains the same, only that under the Trump administration, they're likely to be even more strict. So what is the impact of extending my stay on the B1, B2 visa? Let me, just for people who are unfamiliar with the process, not the people on this call, but in general who will be listening in. A visa on your passport is merely a permission to arrive at the US airport or sea border or land border. So it is not a guarantee of entry. It just allows you to arrive at the border. Once you come at the airport, most people come through the airport. When you come at the airport, that's where the officers at the airport, technically the Customs and Border Protection Officer, CBP officer, decides how long you can stay. Typically on a tourist visa, they allow you up to 6 months, and normally they give you 6 months. So the question is, once I get in and I have stayed here for 5 months, let's say I want to stay another 3 months or 4 months. Can I extend the stay, or even should I extend the stay? Now, typically, there are a couple of things you have to worry about. First thing is, if you stay in the United States too long, so in any 12-month period, if you have lived in USA for 8-9 months, and in your home country for 2 or 3 months, government can start suspecting that you are actually living in USA and visiting your home country, which is not allowed. So in a subsequent entry, if you come back too soon, they could decline you entry into the United States. They could even cancel your visa. So one fallout of trying to extend your stay is that then you should plan on not coming back for at least a year after you leave. Second is, if your visa stamp is about to expire, let's say you have a 10-year visa and you are in the 9th or 10th year of your visa, and there is an extension of stay in your background, consulates can balk. They can try to not give you a restamping of the tourist visa. So extension can cause delay in coming back to the USA, and if your visa is about to expire, it can cause issues in getting your tourist visa stamped again. Now let's look at the questions that NCL has made or put down. I have my parents here on B2 visa. I-94 is expiring December 25th. I need a recommendation how to approach. Can I extend their stay? And I just covered that. How many days before I-94 expiry should we extend? I would say at least 30 days, because once you file the extension, then they can continue to stay here awaiting a result of the adjudication on their extension request, but make sure they don't go past the requested time. So let's say that in December, you apply for a 3-month extension to February or March, and the extension is still pending. They should leave in March anyway, and keep evidence that the extension was filed. That's pretty much all the questions you had here, and I think I have covered them. *5 on your phone, press *5 if you have a follow-up question. No new questions, please. Just a follow-up question. Okay. Let's go on to the next frequently asked question, which is also very commonly being asked. So I am applying for an H-1B where I'm going to work at an end client site, but I don't have a letter from the end client, which is common because you're not yet working there. However, the end client letter will be given to me once I've been working there for a couple of months. What should I do? If H-1B amendment is filed without client letter, is it okay? I believe so. I don't see why not. I'm hearing after September 11 client letter is mandatory for filing H-1B amendment. I don't see it like that. The government does have the right to deny cases which they believe are missing essential documentation. But again, I don't know the mind of Trump administration. Trump administration itself doesn't know what its mind is. So I don't know what they would do, but it's not like you've got 10 choices. So pushed into a corner, I would go ahead and file the amendment without the end client letter. Maybe even point out to the government that the end client letter will not be given to me until I've been working there a couple of months. And as soon as I file the paperwork for amendment, I'm going to start working there. And if you need the letter, please send out an RFE. I would just put it down in the paperwork. *5 if you have a follow-up question. No new questions, please. Press *5 on your phone if you have a follow-up question. Okay, let's go on to the next frequently asked question. Well, this is about NTA's notice to appear, government putting people in deportation if their case is denied. As you know that, or you may not know, that government has backed off this. In fact, if you go to my LinkedIn page, I have made a comment about how NTA policies are being implemented reasonably. So people who have a denial like an H1 or H4, which is on the employment-based visa side, don't have to worry about being issued an NTA for the smallest excuses. So you should be okay. Now, let me look at the question specifically asked by Amin_163. I-140 approved from employer A. H-1B was good till July 2019. 6th year of H-1 ending September 2019. Got H-1B transferred, moved to employer B. Extension is good till 31st December, I guess, of this year. They are starting to file an extension. Premium processing is on hold. Wife's H4 is good till December. He wants to send her back because there's a possibility of getting an NTA. I think you are wrong. As long as you file her H4 along with your H1 asking for an extension, I don't see why there's a problem. If the decision is denial, I have to go back to India. Will my employer be able to file for me from India? Absolutely. They can file while you are in India. They won't be filing from India, but your US employer, H1B cannot be filed by a non-American employer. It has to be a US employer. So they can file for your H1 even though you are in India. In case of extension denial, can I go back to my old employer if they have not revoked my old H1B? The answer is yes. The new regulations specifically permit that. The new regulations specifically allow that. Star 5 if you have a follow-up question. Star 5. Okay. Let's go on to the next frequently asked question, if there is one. Okay, these were all the frequently asked questions. Now let's get started with the regular questions. The first one is from SampQ6699. I'm about to marry a green card holder. I'm in India right now. What procedure should I follow after the marriage? You don't really have much to do. Once the I-130 is filed by your spouse, it gets approved and the file gets sent to the National Visa Center in New Hampshire, USA, from where they will send certain papers for your spouse in the United States to sign. Once they sign that paperwork, including affidavit of support, etc., and send it back to the NVC, National Visa Center, New Hampshire, the paperwork will then be forwarded to the consulate chosen by you guys closest to your place of residence outside USA. And eventually you'll be asked to take the medical examinations and show up for an interview at the consulate. I don't see what you have to or can do in this process. Star 5 if you have a follow-up question on this. No new questions? Any follow-up questions on this? Okay. Sunil Kaushik says, when changing jobs on the AC21 using supplement J, how is the job similarly derived for a person who has applied from EB1C category? Okay. Now, this is in some ways a difficult question to answer, and in some ways it's an easy question to answer. The common sense answer is quite easy, that if, let's say, you were manager product delivery, you were a product delivery manager in a software company. Basically, your role is to make sure that the project is completed and delivered on time. Let's say now you move on to another company and your next job is a product delivery manager. Now this one is easy. It's the same job. The product may be different. Let's say in the old job you were doing financial software, and in the new job you're doing cybersecurity software. But the nature of the job is the same. You make sure that things get delivered on time. How about if you go from being a product development manager or product delivery manager to something totally different? For instance, you become a database administrator. Now that obviously is not same or similar job, so you won't get AC21 benefits for it. But let's say you get promoted to Chief Technology Officer in the next job. Can this be considered to be same or similar to product delivery? And the answer is probably, because if you have worked in product delivery as a manager, you are very aware of technology, how it is deployed, how it is used, and how to manage enterprise level resources. Chances are we can make a case that a CTO is just a step up from being a product delivery manager, and that product delivery manager prepares you for the job of CTO. So those are the two key questions. Is it a step up or a step sideways, basically. But the more important thing is, does the earlier job make you qualified to perform the later job? So the fact that you were working as a manager for product delivery, and there is a lot of technological components of that job that are the same as those for a CTO, I think a case can be made. Now, there is actually this was the common sense answer. There's actually a technical memorandum which I can never remember the details of. It's out there. You can look for it, and it may even be in the policy manual on the USCIS website, or it'll definitely be there under uscis.gov laws and memoranda, and look for the memoranda on AC21. So they have a very detailed description of what they consider same or similar based upon the job categories, like you have described, management consultants, going from management occupations like financial managers to top executives, chief executives, like the example I was taking. I think these are same or similar, but I would not want to make a guess, because remember, the devil is in the details. We would have to compare the two job descriptions, the one for which your green card was filed and the one you're going to. And of course, one thing is quite clear, that EB1C category of international managers and executives does qualify for AC21 portability of green card. *5, if you have a follow-up question on this. No new questions. *5 for a follow-up question. Okay, I have one so far. And let's see. And it's from Florida. Okay. Yes, Florida, go ahead, please. I can hear you.
Hey, Rajiv, this is Sunil again. Yes. My only question is, on the I-140, you have the job code, which is that, say that 113031, which is code. In AC21, when you file it, do you put a job code like that? And does it go to the family, or is it an exact 1:1 match? I know that there's a technical memorandum, but I want to know if there's a quick and easy answer.
I don't know whether we put an exact code. I don't think we do on Supplement J, because I don't fill forms. Forms are filled by other people who are better at it than I am in our office. I am the strategy person, so I don't deal with those level of nitty-gritty details. I do review the forms, but I don't remember that. I don't think I've been ever asked by any member of my team what code should I put. Normally, when they are dealing with complex jobs, sometimes they come back and ask me, and they do that all the time when it is filing for prevailing wage for a green card, etc., because there you need the codes. So I'm not sure you have to put in a specific code. And what I described to you about the jobs, remember the terms used in the statute are, the two jobs must be same or similar. Obviously, the word similar implies that the jobs are not the same, right? So therefore, similar by necessity and by definition has to be something less than same. How far less would depend upon the job description, not the job title. Okay.
Understood. Understood. Thank you.
You're welcome. Good luck. Okay, let's go on to the next question from Vaibhav2512. So he was on STEM OPT, got picked up in the H-1B lottery. H-1B was approved with change of status from October 1st for New York. They laid you off. You shifted to this new job in Ohio in August with the same employer. The university updated the service portal online. On September 25th, an amended H-1B for this job in Ohio reached USCIS, and the case is still pending. So let's look at this situation one more time. So you got the change of status, but before you got the change of status, they laid you off, and you went on to maintain F1 status, did all the necessary formalities with your university. Then on September 25th, you filed an H-1B amendment. Actually, a transfer, not really an amendment, because you're with a different employer, right? Yeah. Different employer. So, you are now working on F1. Oh, you are currently working in Ohio on H-1B status as my F-1B status ended. That doesn't make sense. On September 25th, an amended petition was filed. How can you continue working? Because if your OPT has expired, you have already foregone, although a questionable procedure, by stating to the government that you're still maintaining your F1. So you never received a change of status. So I don't know how you are continuing to work on H1. If OPT is expired, you should be sitting back and letting it play out. Suppose my new H-1B petition for Ohio gets rejected. Do I have unlawful presence? Well, I don't know the answer to that question. Let's try to think it through. So you had F1, you continued to maintain F1. Yeah, your unlawful presence, I don't recall the exact details of the government's new policy, but I believe unauthorized employment triggers it. So you have no employment authorization as of October 1st, and you are right. I think you've been accruing unlawful presence from October 1st. There's been a lawsuit filed against this policy last week, or was it this week, from North Carolina. Let's see how that lawsuit progresses. But for now, just remember that it's best to assume that you've been accruing unlawful presence from October 1st. Would I have to leave USA immediately? Well, that is definitely an option, but I don't want you to take any precipitous steps without discussing it with your lawyers in further detail. But I do think you've started accruing unlawful presence from October 1st. Star 5, if you have a follow-up question, press star 5 on your phone, please. Okay, so I have two questions, it looks like. One is from Pittsburgh, and the other one is from Washington State. Let's start with, I believe this is Pittsburgh. Yeah, Pittsburgh, go ahead, please.
Hi, this is Rajiv. I don't know if you understood my question correctly, but I'm still working with the same employer.
You're still working with the
Ohio.
same employer. Okay, let's take another. Oh, so amendment.
Yeah.
It doesn't matter, amendment or transfer. They did revoke your H1, right? They withdraw your H1?
No, they did not, because there was never a separation of employment.
Okay. Let me take a look. Then I misunderstood the question. My H-1B petition was approved from October 1st. My employer laid me off from this job and offered me a new job in Ohio. So the same employer. Oh, I see. I shifted to this new job with the same employer. I see. But I still don't see how you can continue working, because you declined to accept the H-1B change of status, right? Or did you?
No, I accepted it.
Oh.
I mean, it was automatically approved
okay.
from
So you
October
didn't.
1st.
I thought what you did was, okay, that's why I misunderstood. Thank you for correcting me, because what I understood you to say is that you left the employer, you moved on to a new location, you called the school and told them you're not accepting the change of status. You want to remain on F1. Okay. Not sure that can be done, but that's the way I understood it. Now, what you're telling me is you just moved to a different job location for the same employer while you are still on F1. And your employer, before October 1st, which is September 25th, applied for an amendment for this job in Ohio. So that's your situation, right?
Yes.
Okay. So first of all, there is no unlawful presence, because your case for amendment was filed before October 1st, when you would have been obliged to start working on an H-1B. So because you have an amendment, now there's an interesting portability issue. If you look at the AC-21 portability law, it says that people who have been maintaining H-1B status can start working at a new location as soon as the amendment is filed. Now the question is, you were not maintaining H-1B status on September 25th because it hadn't started yet. I think it's such a fine tertiary issue of law that you're not going to have any problem. In my view, there's definitely no unlawful presence from October 1st. That's for sure. And I don't think
And right now I am...
Yeah. Go ahead.
And right now I am on H1B, right? Because F1
Yes.
automatically
Yes.
converted to H1B.
Yes.
Okay.
Yes. Okay.
Okay. Yeah. Thanks a lot.
You're
Thank
welcome.
you.
Good luck, sir. Okay, area code 412, oh no, 206, Washington. Go ahead, please. Washington. Area code 206. Okay, I'll put your hand down. I guess that could have been a mistake.
Hello.
Okay, I think you said hello. Let me try to unmute you. Hi, I can hear you. Go ahead, please.
Okay, sir. My question is, I was a doctor on H-1B, and my I-94 is expiring in August of next year. So I got laid off on the 12th of September, and according to the 60-day discretionary grace period, I have till November the 10th. I have got a new employer who is an H-1B cap exempt employer.
I remember getting an email from you, Doc.
Yes, sir. You responded. So just to clarify that question, sir, they are willing to put forward the H-1B, but I think I will be just outside the date, because if they start in LCA the earliest on Monday, I'm assuming LCA takes around 7 to 10 working days, correct, sir?
10 days, yeah, somewhere there. I don't know if it's 10 working, I think it's 10
Right.
days, 10 calendar days.
Okay. The 10 calendar days would be just 2 days before the expiry of the 60 days. So my question was, is it okay for the same employer if I ask the attorney to do an O1 as a regular processing and then start the H-1B as a premium because it's cap exempt? I'm assuming premium is still available for cap exempt H-1B, correct?
I believe so. I don't remember the exact details, but I think cap exempt premium was available.
So would it, supposing the H-1B cap exempt and premium is accepted, and if I withdraw the O1, would that matter at all? Would they say that you used it as a placeholder and therefore we are
I don't
withdrawing
think
it?
it's going to accomplish what you want it to accomplish. What you really want is a transition from H1 to H1 without having to leave USA. That purpose it won't accomplish, because unless the O1 is decided in your favor, it is just pending. So anytime you're in between two statuses with a pending status request, you are in authorized period of stay, which is less than full status. Government won't give you status from an authorized period of stay. You have to be in full status. So chances are mere pendency of the O1 will not provide you the bridge that you need to seamlessly transition from H1 to H1. But it does prevent accrual of unlawful presence.
Right. So then supposing the H-1B gets accepted, then I would need to leave the country and have a new stamp put in, correct?
You might, because of that gap, but again, it's up to the USCIS. If they choose, they can definitely quote unquote forgive the out of status period.
Okay.
All right.
Okay. Okay. Thank you so much, sir. Appreciate all the help for the community you're doing.
You're
sir.
welcome, sir. Good luck to you.
Thank you. Thank you.
Okay, let's go on to the next question from Panis. Clarification regarding concurrent H1B. Yeah, sometimes the forms are not very efficient. There is no place in the form DS-160 to add your part-time H1B details. So in a situation like this, I would kind of stick that in there wherever there is a little room, saying that please note that I have a concurrent H1B. There's no place on the forms. I'm just putting the information here. I know there is enough room. You can just put it anywhere and make that observation. *5 if you have a follow-up question. *5. Okay, let's go on to the next question. Dinesh, I'm on L1B blanket. Visa expires 2019. I-129 May 2019. Should I go for an L1B extension or an L1A? Well, there are pros and cons. L1Bs tend to be a lot more difficult these days to get approved than L1A if you have a good case. But somebody will have to assess for you whether you have a better case for an L1B or an L1A. They'll have to look at your job description, your company, what sort of work are you doing. So all sorts of things go into this. It isn't a decision I can help you make without reviewing everything about your case. So as a general matter, L1As in good cases are usually easier to get approved. Now you said you don't have any direct reportees in USA, but I have a team in India. That team does count. I have seen a decision from the Administrative Appeals Office that says that we are going to count those people who are within the umbrella of the same company, even though they are not physically located inside the USA. So I do think you can factor them in when you ask the government for an L1A. Another advantage of L1A is the total period allowed is 7 years as opposed to 5 on an L1B. Of course, getting an H1B is always a good idea, but remember, you'll be able to file an H1B only for the amount of time that remains on your 6 years after you deduct the L1 time. So if you have been on L1 for 4 years, you have only 2 years of H1B left, even if you get selected in the lottery. Okay. *5 if you have a follow-up question. *5. Okay, let's go on to the next question. Sridhar, which is Mr. Pacific, says, my priority date is June 2010. I-140-45 were applied in 2011 separately. EAD was received 2012, changed my job, kept my H1 active, filed AC-21. Should I file AC-21 and 485J? Well, now you don't file anything called AC-21. You file a supplement J each time you change employers, and you're going to stay there for a while. So yeah, you would be filing supplement J now. Okay. I just got a raised hand from somebody. I don't know what that's all about, because we were already done with the previous question and I have not stopped answering the present one. So we'll get to it. But in any case, if you have a follow-up question on this, Sridhar or somebody else, press *5 on your phone. Okay, so I have probably a voice over IP who just raised their hand. I don't know what phone number they're calling from. Go ahead, I can hear you.
Hey Rajiv, thanks. This is Dinesh. Okay, so thanks for answering my question. So I got your point. So for regarding the conversion to the L1A, so since I did not perform any managerial role outside of US, so will that matter?
Well, there is a, I don't remember the exact detail of the regulation, but there's a regulation that says if you have been performing managerial duties for 6 months after entering USA inside the USA, you can apply for an L1A. You will not be able to apply for a green card through EB1C category, but you should be able to apply for an L1A. Okay?
Okay. Okay.
Good luck.
I mean, suppose another question. Sorry, another question. So suppose if I am going for an H1B, so once my I-140 approved, so will I able to do one extension?
Yes.
I mean, will I able to do a COS to L1A again?
Yes, you can. If your I-140 is approved, you should be able to. Now, my only concern is the regulations get a little murky there. If you have never had an H1 before and you want to use I-140 to quote-unquote extend your H1, can you? I do not know the answer to that question. But if you have had an H1B even for 10 days and then you have to extend it for another 3 years with the I-140, you can. Okay?
Okay.
Good luck to you, sir.
Thank you, sir.
You are welcome.
Thank you.
Let's go on to the next question. Guys, try to be quick about asking your questions. It will get confusing for people who listen to this if we keep going back to an earlier question. My role says I have an approved I-140 under EB2 from employer A. Now employer B is offering a full-time offer. They'll start my H1 transfer, but they won't file under EB2 category. Manager convinced me that there'll be job leveling next year. They can port back from EB3 to EB2. I don't know what that means. I guess if they mean they will refile the green card under EB2 category, the answer is that's fine. But there's no provision for porting from EB3 to EB2 except through filing a new green card. Your question is, how much of a risk is this? I don't know what this is. I don't know what they are thinking. If employer A did not revoke my I-140, my EB2 dates become current. What are the options? Well, you obviously cannot file a 485 through the sponsoring employer unless the sponsoring employer has a job for you. But because your 485 is pending, let's see, did you file 485? No, not yet. Okay, your 485 is not pending. The good news is, even if the old employer A revokes your I-140, it does not take away your priority date, nor does it take away your right to keep extending your H1 beyond 6 years if your I-140 stayed approved for 180 days after it was approved, and if any one of those 180 days falls on January 17th, 2017. So if your green card was if your I lost the train of my thought there for a second. If your I-140 was approved, let's say 179 days prior to January 17th, and January 17th was the 180th day, on January 18th they revoked your I-140, you are entitled to both your priority date as well as the right to extend your H1 beyond 6 years through any employer. So even if employer did not revoke your I-140, you cannot file a 485 unless they are offering you a job back. Can I join employer B or stay with employer A? That's a personal choice. I'm not sure I can answer that. That's a question that is totally career oriented. Immigration law wise, it doesn't make a difference to us. *5 if you have a follow-up question on this. Press *5. Okay, let's go on to the next question. This is from Anvesh. My labor was approved in May, filed for I-140 and EB2 premium processing, received an eligibility to pay wages. RFE case was denied. Employer claims they're going to fight this. You could even do premium because it doesn't hurt to try. What happens is, if the I-140 was recently denied and you filed another one and they still have access to the original PERM application, USCIS may premium the case as you request, even though you don't have an original PERM. So you can try. So there are three approaches that you see: MTR, AAO, and reapply with the same labor as the labor is still inside 6 months. Well, interestingly, your first I-140 has to be filed within 180 days. The subsequent I-140s can go past 180 days. So the 180-day rule doesn't apply to subsequent applications. Can I proceed with MTR and reapply as well? You can try, but they won't decide your MTR. They'll probably dismiss your MTR if you refile. And so it is with the appeal as well. I don't know what your case is. You said, how strong is my case? We'll have to review your paperwork. I can't just give you an opinion based upon a few sentences in a message. None of that I can answer. What are my chances, etc. Should I start the labor process again? Well, the ability to pay wages issues, we've been able to resolve most of them. Your lawyer should also be able to, at least, because there is an argument called totality of circumstances test, where you don't just look at the tax returns, but you look at the overall environment of the company. So for example, if you are a software company and let's say you developed some new software that you're now selling. So the first 3 years you were developing software, obviously you had no income. So there is a reason that you did not have income as a company. 4th and 5th year onwards, things might be different. So totality of circumstances test may win you the case. I do not know what your case is. I wouldn't start looking for a better employer just yet. I think you should take an opinion, take a second opinion. You can, of course, approach us. You can send me an email at help@immigration.com. We can take a look at it. You have somebody else you trust. Take a second opinion. Find out what the strength of your case is. At least get that much cleared up. And if the employer wants to be extra nice to you, a second PERM application should also be considered so that you are protected from every angle. Star 5. If you have a follow-up question, star 5. Star 5 on your phone if you have a follow-up question. Okay. Anup GC says, I am on USA on a green card employment based. I'm not a special registrant. So you just neglected to file AR11 for one of the residences. You have to mention all the addresses. You can't conceal anything during your naturalization application. I don't think the government is going to deport you. Technically, it is a problem if you don't file a change of address form, but I would be surprised if the government wants to make an issue. However, with this government, you never know. Have somebody look at the law on that in detail, see what your exposure is. I am just speaking off my memory. I have never known anybody to get into trouble for failure to file AR11. I have seen those situations come up only when we are trying to do a plea bargain in a immigration law violation of a criminal nature, where I've seen companies plead to failure to file AR11 or something like that, just as a matter of plea bargaining. But I've never known anybody to get into trouble. I'm hoping that trend continues, but I don't know off the top of my head what your exposure is. I'll have to look at the regulations and review the case law. Star 5 if you have a follow-up question. So yeah, you should definitely reveal it. Don't try to conceal it. It doesn't matter how long they maintain the change of address history, because they will find out. Okay, no question. Let's go on to the next one. These two were frequently, these three were frequently asked questions. We've already done them. And then I have 15 minutes left for this call. I'll do the best I can. I have another call scheduled at 1:30, so I'll have to run exactly sharply on time. Anumolu says, my green card was filed EB2 category in 2011. I had worked in the same firm for 7 years in India. You were a technical lead. You want to file under EB1C category. Well, if you were working for the same company, you might be able to file, and again, I don't remember, there was a slight change in the regulations or in the interpretation of the regulations in this respect. But if you have been consistently working for the same company, even after 7 years, you might be able to file an EB1C case. I'm not convinced a technical lead is a managerial or an executive position. One key difference between executives and non-executives is that the executives are not involved in the production of the activity or the service, whereas typically a technical lead is merely a senior level technical guy who's directly involved in the activity itself. So I'm not sure you will make it as a manager, but really it is not the title, it is the job description that matters. So theoretically possible, practically somebody should look at. *5 if you have a follow-up question on this. Now, the next question, I have a little bit of a concern. Erickson 18, I won't be able to help you fill forms. That would require me to sign the forms. But when somebody has been denied an entry and they have withdrawn their application for admission, usually that is not a big problem. But 212A7, that concerns me. I don't recall, is this a fraud ground? Because if it is a fraud ground, that's a permanent bar from entering the US. 212A7, let me just do a quick Google search on this. If I remember correctly, that's a fraud ground. Let's do a quick Google search on 212A7. I think those are criminal grounds. Just checking for you, 212A7. Maybe not. Voluntary withdrawal. 212A7A12. Yeah, it looks like, I'm sorry, I'm mistaken. 212A7A11. If it is just voluntary withdrawal, there was no other issue. Yeah, it looks like A1. Yeah, that is exactly what it is. Voluntary withdrawal. Then there is no, it doesn't carry any disqualification with it. That denial should not hurt her. Okay, I can't help you fill the forms, so if you need the form filled, you may want to talk to a lawyer locally there. But at least from what I can tell from the facts that you've given us, I don't think she's going to have any major issue getting a green card through you. *5 if you have a follow-up question. Okay. H1B status was, this is P. Joshi. H1B status was recently updated on USCIS website as approved. It's been over 3 weeks. I haven't received a hard copy. Yeah, just open a service ticket. Call the USCIS customer service and ask them to open a service ticket. *5 if you have a follow-up question. *5. So there is one follow-up question. I'll get to it in 1 second. Going back to 205, area code 205. I guess that's Alabama. Yeah, Alabama, go ahead, please.
Yes, hi. Hi, Rajiv. Thank you for your services. I'm actually a new poster, so I'm sorry if I have not written the entire thing, but it's an approval notice has not been received, but I still have the courtesy copy with no I-94 attached on it.
That's good enough. Did you get your I-94 approval also?
I haven't, because my service records, my college says my service records have not been updated yet. I do not have the approval notice, although I have a courtesy notice which has validity dates and type of notice as approval. I wasn't sure if I can take that as a form of document for visa interview in India.
If you are going to India, I think that should be okay. But if you want to be even more sure, you can send an email to the consulate in India and say that I'm just coming with a courtesy approval notice. Is that good enough? Normally they should accept that because they have a complete copy of your paperwork in their PIMS database system anyway. Okay. So
okay, because I was under an impression of whether it is a consular process or is it a change of status, because my service records also have not been approved.
Even if it is a change of status, if you are going to go for a visa stamping, the consulate should have a complete copy of your paperwork in their database anyway. Okay?
Okay. All right.
Good luck.
Thank you so much.
Oh, you're welcome. Okay.
Thank you.
You're welcome. I have a very long set of questions here. I'm not sure I can get through all of them in the 10 minutes that I have remaining. I'll do my best, but I have one question that is shorter, the last question. I will answer that first and then try to answer as much of the long question that has been posted. Bear in mind, like I said, I've got to leave. I've got a 1:30 appointment. So Kuldeep says, at present, my I-140 is approved from some other consultant as a future employer. Date is December 2017. Max out, I guess H1 max out is July 2019. Their current company is planning to apply for new green card. Well, first of all, if your old I-140 stayed approved for 180 days and any one of that 180 days fell on December 17, 2017, that means if your I-140 is revoked after December 17, 2017, did I say December? No, January 17th. Then in that case, you don't have to worry even if the I-140 is revoked, because your right to keep extending H1 beyond 6 years through any employer remains intact. My current company is planning to apply for my new green card. Is it advisable to port my approved I-140? You don't port your I-140. Your priority date, once the I-140 gets approved, is attached to you. It is not attached to the I-140 or to the employer. So if anybody files a green card for you, you should automatically be given the earlier priority date because it is attached to you. There is no ground for getting a green card faster on humanitarian grounds. No. Parents coming on a B1, B2 visa. Well, I don't know what you mean. Is it advisable to enter after 1 month gap? You can't do that. As I stated earlier during discussions on B1, B2 extensions, if you stay in USA and visit your home country, at some point you'll be declined entry. The government can even stop you from coming back for a certain period of time. I think 4 or 5 months during a 12-month period is probably acceptable, maybe even 6. But if you go more than that, you are exposing yourself to a possible denial and maybe a future visa stamping issue in case the visa expires. *5 if you have a follow-up question on this. *5 on your phone, please. Okay, so this is the longest question. I'm going to spend the next 7 minutes that I have on this. I'll cover the best I can. I've lived in USA more than 50 years, got my green card valid till 2021. Green cards can be renewed. That validity doesn't mean anything. So first question is, are green card holders at greater risk of removal than US citizens? US citizens cannot be removed. They are immune from removal. If you want to remove a US citizen, first you have to denaturalize them. For instance, if they procured their naturalization through fraud or something. So you can't just deport a US citizen even if it is a naturalized citizen. Obviously, green card holders have much greater risk of removal than US citizens. Marijuana convictions are extremely complicated. I just studied this for somebody who had a marijuana conviction. And you will be surprised to note that There's a difference between federal laws and state laws, and there's a difference whether you are entering USA or being removed from USA. So inadmissibility and grounds of deportation are different. If a conviction is expunged, it doesn't mean anything. Under immigration laws, you are still subject to the same problems, and you are required to reveal those convictions. The only thing that will make the conviction go away is some kind of a action before the court that causes that particular conviction to be removed, not just from the record as expungement, but reopened and vacated. That's called a vacatur, or some places it's called a writ of audita querela. So basically the case has to be reopened. Then expunged is not good, but vacated is good, yes. You can send in a request for an FBI report. I don't know of any other comprehensive way. You were recently issued an airport badge. I don't know how that application gets cleared. You'll have to do the homework, just as I would, if you're talking about some kind of an expedited visitor status or pass-through status. I don't know what kind of investigations they do. If you are behind on your taxes, that can be a problem for naturalization, yes. We hear a lot of rumors about government trying to change immigration laws, but you know that they cannot do that without congressional action. Now, as far as getting medical benefits is concerned, I, of course, cannot answer that question without reviewing everything in detail. As of today, the law still is the only two things that are a problem if you are getting cash assistance to supplement your income, or if you are in long-term assisted care facility. They haven't yet changed the regulations. They are planning to. I don't know what that means. Is there any risk to travel internationally? Oh, yeah, I see what you're saying. So, yeah, sometimes people at the airport are not well trained, so they can definitely delay you. Seems like U.S. constitutional rights are out the window. Well, how is this all allowed to happen? Well, first of all, remember, Constitution doesn't extend to people outside the U.S. So, the way the law works is that if you are coming from outside the USA, you don't have all the constitutional protections that are normally available. But if you are a green card holder and you have been outside USA for less than 6 months, you have pretty much all the protections that you need. And then short-term Oklahoma City marriage. She just disappeared. No children, no property. Maybe she's passed away. You need to just get yourself something called a skip tracer or a private investigator and figure out what is going on with your ex-spouse. You can always, there is always a possibility, most courts, I'm not a Texas lawyer, nor am I an expert in domestic relations law. Generally speaking, when you cannot find a defendant, for example, your ex-wife, you can always do a divorce through publication in the local newspapers. And that's as good a divorce as if the parties were actually standing across from each other. So you should definitely talk with a local domestic relations lawyer, somebody who does divorces, and then based upon that take the actions necessary to formalize the divorce. That would be the obvious option. Okay, and this is really a domestic relations issue. All your questions there, nothing to do with immigration law. I wouldn't know anything about it. Folks, I've got to run. As always, I always enjoy talking with all of you. but today I'm a little pressed for time, so we've been able to deal with all the questions that were posted. I'll see you again in 2 weeks. Thank you very much for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.